The Supreme Court today continued hearing the batch of petitions challenging the Karnataka High Court's judgment which upheld the ban on wearing of hijab by Muslim girl students in some schools and colleges in the state. The matter was heard by a bench comprising Justices Hemant, Gupta and Sudhanshu, Dhulia. The hearing in this case will resume tomorrow at 11:30 am. To provide a bit of context for our viewers who are not aware of this issue, the Karnataka High Court on March 15th this year had upheld a Karnataka government order dated February 5th, effectively empowering college development committees of government colleges in the state to ban the wearing of hijab by Muslim girl students in college campuses. We have covered in detail in our earlier video the arguments advanced by various parties on the last date of hearing that took place on Monday, the link to which has been given in the description box below. Let us now see what transpired in the court today and what exactly were the arguments made by the respective counsels. Today, Senior Advocate Devadatt Kamath, appearing for the petitioner in the lead petition, underscored that Article 19 of the Constitution of India, which provides citizens with the right to freedom of expression, also included the freedom to dress. He pointed out that the reasonable restrictions under Article 19 Clause 2 relating to public order morality do not get attracted in the present case, and also highlighted that the petitioner was not opposed to wearing the uniform but that she just wished to wear the uniform along with the headscarf. If I wear a headscarf whose morality is offended, whether the wearing of headscarf matching the color of uniform is offending anyone else's fundamental rights or legitimate state interest so as to warrant the state issuing the government order? Senior Advocate Kamath said during the hearing today. Justice Gupta was, however, quick to retort to this line of argumentation by stating that Senior Advocate Kamath was taking the submission of freedom of expression, including the freedom to dress, to illogical ends, and also inquired if the right to dress would also include the right to undress. Justice Gupta remarked, and I quote, "You can't take it to illogical ends, right to dress will include right to undress also." Responding to this, Senior Advocate Kamath stated, and I quote, "Nobody is undressing in a school. Question is wearing of this additional dress as part of Article 19. Can it be restricted?" Even during the last hearing that took place on Monday, Justice Gupta had asked if the female students could be permitted to come to school in middies, mini skirts as per their choice. Furthering his argument, Kamath contended today that the petitioners were compliant with the school uniform as they only sought to wear a headscarf in addition to the uniform. He also questioned as to how a headscarf of the same color could cause any indiscipline. He highlighted that the petitioners were not seeking to wear apparels such as the burqa or the jilbab. During the hearing today, Kamath also apprised the bench that even Kendriya Vidyalayas under the central government permitted students to wear headscarves that match the color of the uniform. Referring to the impugned Karnataka government order, Kamath argued that by disallowing the hijab, the order targets one community and their fundamental right guaranteed under Article 25 of the Constitution, which stipulates the freedom to profess one's religion. However, Justice Gupta refuted such a submission by stating, and I quote, "Your reading of the government order may not be correct because it is only one community which wants to come in religious dress." This prompted Kamath to highlight alleged instances of students from other religions wearing purported religious symbols to schools such as the Rudraksha, cross, Naman, etc. However, Justice Gupta responded by stating that the cross or the Rudraksha are different as they are worn inside the dress and are not visible to others, and thus there is no violation of discipline. Kamath then responded by highlighting that the issue in this case is about the principle of reasonable accommodation and not about what is visible or not. Importantly, while talking about constitutional secularism, Kamath pointed out that secularism in India is not the concept of negative secularism as followed in countries like France or Turkey, where display of religion in public is offensive. He highlighted that the constitutional standpoint is that all religions are manifestations of the same God. During the hearing today, Kamath also heavily relied upon a judgment of the Constitutional Court of South Africa pertaining to the right of a Hindu girl from South India to wear a nose ring. The South African court had held that asking the girl to remove the nose ring even for a short period will send out the message that she and her religion are not welcome. He also referred to a 2015 US Supreme Court decision which had allowed headscarf in employment. However, Justice Gupta dismissed such a contention by stating that India cannot be compared with jurisdictions such as the USA or the Canada, as India is a conservative society. While expressing his disagreement with the reasoning given by the Karnataka High Court while upholding the hijab ban, Kamath argued, and I quote again, "High Court said forcing a girl to wear hijab will militate against Article 14. Nobody is forcing a girl to wear a hijab. The question is, if a girl is wearing a hijab out of choice, can it be prohibited?" Importantly, he also submitted that if the petitioners in this case succeed in showing that there can be no restriction on their right to wear a hijab, then they don't have to go into the question as to whether hijab constitutes an essential religious practice under Article 25 of the Constitution. Pursuant to these submissions, the bench adjourned the matter and the matter is slated to be heard again tomorrow. Thank you. This is Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.